See, in the previous video, I explained about the Supreme Court. Okay, now here I am going to discuss about the High Court and subordinate courts related to the judicial system. See, in the Constitution of India, okay, Article 124 to 147 of Part 5 of the Constitution, okay, deals with the Supreme Court. Okay, now Article 124 to 147 in Part 5 of the Constitution deals with the Supreme Court. So the Supreme Court is at the center level, and High Court, if I consider Article 214 to the 231 in Part 6 of the Constitution deals with the High Court. Then subordinate courts, Article 233 to 237 of Part 6 of the Constitution. So High Court and subordinate courts are at the state level and Supreme Court is at the central level. So as per the Constitution of India, the Supreme Court, High Court and subordinate courts are there. Okay, na? Supreme Court at the central level, High Court and subordinate courts are there at the state level. Actually, this judicial system came from the Government of India Act 1935. Okay, the India Single Integrated Judicial System adopted from the Government of India Act 1935. So this is the basic information about the High Court, Supreme Court and subordinate courts as per the Constitution of India. Now in this video, I will explain in a different format like Supreme Court and High Court. Like you can say the qualifications of a judge for Supreme Court and High Court, the powers of Supreme Court and High Court in a different format, the pleading power, all these things, tenure, all these things, salaries, allowances, in a different format I'll explain so that you can easily understand that, right? Now, before going to that, I'll give you some more points. See, the High Court is a territorial jurisdiction. Okay, territorial jurisdiction means within India, okay, one particular boundary, okay, this will work. Okay, and two or more states or union territories may have a common High Court. Like suppose you can take Puducherry, Pondicherry we call it as, and Tamil Nadu have a common High Court. Okay, na? So like that, two or more states and one state and one union territory may have a common High Court. The Parliament can extend the jurisdiction of High Court to any union territory. So Parliament has a power to extend the jurisdiction of High Court to any union territory, or excludes the jurisdiction of High Court from any union territory. So Parliament has a power to include or to exclude any union territory of a High Court. Okay, na? Right? Now, see here, let us consider the comparison here I am giving so that you can easily understand, right? The Supreme Court and High Court. See, the meaning of Supreme Court, as you know that the Supreme Court is the primary court of justice in the country. The Supreme Court is the primary court of justice in the country. But High Court is the apex judiciary body. High Court is the apex judiciary body of a state administration. So High Court is present up to a state level. State level, topmost state level primary court we can say is a High Court. State level primary court is a High Court. Articles in the Constitution. See, for Supreme Court, Article 124 to 147 of Part 5th will give you the details related to the Supreme Court in the Constitution of India. And Article 214 to 231 of Part 6th will give you the details about the High Court in the Constitution of India. Okay, na? Who is headed by the Supreme Court of India? See, who is headed by the Supreme Court of India? It is headed by the Chief Justice of India. See, who is the head of the Supreme Court? Chief Justice of India. But in High Court, The High Court is headed by the Chief Justice of that particular state, Chief Justice of that particular state of High Court. Okay, na? Chief Justice of India, Chief Justice of the state. Right? The number of courts, see, the number of courts at a central level, there is only one court, Supreme Court. Okay? There is only one Supreme Court in India. There is only one Supreme Court in India. Only one Supreme Court in India. But the high courts, there are so many high courts. See, there are total 25 high courts. There are total 25 high courts in India, 3 of which have jurisdiction in more than one state. There are 25 high courts in India. Okay, right. So, three high courts have jurisdiction more than one state. But Supreme Court is only one Supreme Court. But high courts, there are 25 high courts are there. Remember. Now, see here, the superintendent or territorial jurisdiction. See, Supreme Court, if I consider overall courts and tribunals of the country. So, the Supreme Court is the head of all the courts and all the tribunals in the country. Okay, all the courts and all tribunals work under the Supreme Court. Now, if we talk about the High Court, okay, so below the High Court, like district courts are there, they are also working under the High Court, right? See, overall courts under its jurisdiction, okay, state level, suppose you take Telangana High Court is there, right? So, below that Telangana High Court, there are Telangana, so many district courts are there, municipal courts are there, like that. All these are working under Telangana High Court, okay, na? Which in turn is limited by the boundary. So, it is related to the boundary only in Telangana boundary, only this is related to Telangana High Court. Okay, na? In more than one state, sometimes one high court will work on more than one state. So, suppose one high court is working on 2 states. So, the 2 state boundary jurisdiction comes under this high court. Okay, na? Now, writ jurisdiction. See, the Supreme Court can issue writs like we discussed in the previous lecture, like to protect the fundamental rights, the Supreme Court have the powers like habeas corpus, quo warranto, mandamus, like that, certiorari, like that. So, the Supreme Court has power to issue the writs, right? Supreme Court can issue writs only where a fundamental right has been infringed or fundamental right has been violated. So, Supreme Court can issue the writs. At the same way, the High Court also can issue the writs within the boundary. See, the High Court can issue writs, right, for the enforcement of the fundamental right as well as the other purposes, that is ordinary legal rights of citizen in the state. Remember, in the state, within the state. So suppose if a person is not getting the basic fundamental right, then he can approach directly to the Supreme Court, or he can also approach to the concerned High Court. So, High Court can issue the writs, Supreme Court also can issue the writs. Okay. So, writ jurisdiction both the courts have. Now, next, qualification of judges. Qualification of judges. So, if you talk about a Supreme Court, see here, Supreme Court, if you talk about a Supreme Court, he should be a citizen of India. Okay, Supreme Court, he should be a citizen of India, have been a judge of a High Court or a High Courts in succession for 5 years. So, he has worked as a judge in High Court for 5 years, or advocate in 10 years. So, have been an advocate for High Court or higher courts in succession for 10 years. This is 5 years and this is for 10 years. Be a distinguished jurist in the opinion of the president. So, in the opinion of the president, he is a well-known judge and a popular judge. He has a good jurisdiction, right? Then, if you talk about High Court, okay, he should be a citizen of India. Yes, he should be a citizen of India. He has been a barrister for more than 5 years or been a civil servant for over 10 years along with serving in Jilla court for at least 3 years. Okay, has been a barrister for 5 years or 10 years as a civil servant. Along with that, he has worked in Jilla court at least 3 years. Okay, he has to work in Jilla court at least 3 years. Then only he is eligible to become a judge in High Court. And have been a pleader for over 10 years in any High Court. Okay, has been a pleader for over 10 years in any High Court. So these are the qualifications to become a judge in Supreme Court and to become a judge in High Court. Remember, right? Now, appointment of judges. See, appointment of judges. For Supreme Court, who will appoint? President will appoint. Yes, by the President. Who will appoint? President by warrant under his or her hand and seal after consultation with such a judge of the Supreme Court and High Courts in the state. So, who will appoint the judge of a Supreme Court? Okay, President will appoint. Okay, but at the same time, he may consult with the Chief Justice of India and other judges of Supreme Court, and sometimes if it is necessary, he will also consult High Court judges of concerned state. Right? So, that is the appointment of a judge of Supreme Court. Now, if we talk about the High Court, appointment of a High Court judge, so we will appoint, President will appoint the High Court judge in consultation with the Chief Justice of India and the Governor of the state in question. So, if there is any necessary, okay, consultation if it is required, so we will also consult the Governor of the state. Okay. Who will appoint the judges of High Court? President will appoint the judges of High Court in consultation with the Chief Justice of India and the Governor of state if it is necessary. Governor of state if it is necessary. So, this is the appointment of judges. Now, let us consider this one. The number of judges in the Supreme Court and High Court we will see. The number of judges in the Supreme Court and High Court. In Supreme Court, there are 31 judges including Chief Justice. There are 31 judges including Chief Justice and 30 other, recently you can say 30 judges and 1 Chief Justice. But its strength is increased from 31 to 34. So, at present, the strength of a Supreme Court is 34 including Chief Justice of India. Okay, number of judges in Supreme Court is 34 including Chief Justice of India. Now, for High Court, for every High Court, there is a Chief Justice. Okay, for every High Court, there is a Chief Justice and other judges. The number of judges appointed is defined by the President of India. So, the High Court number of judges is decided by the President of India. Right, decided by the President of India. Right, retirement of judges. See, for a Supreme Court, judges retired at the age of 65 years. For Supreme Court, judges are going to be retired at the age of 65 years. But for High Court, judges retired at the age of 62 years. For High Court, judges are going to be retired at the age of 62 years. For High Court, tenure is like retirement of judges is 65 for Supreme Court. For High Court, only 62 years. And next is pleading. You can see the Supreme Court judge, you can say judge of a Supreme Court cannot plead before any court during his or her tenure or after his or her retirement. See, Supreme Court judge cannot plead in any court, in any High Court, in any subordinate court, even after retirement also. He should plead only in the Supreme Court. Right. Same way, in case of High Court, the judges of High Court cannot plead before any court during his or her tenure. Okay. After retirement, cannot plead in any court below the High Court. So, he should plead either in High Court or above that, Supreme Court. Here also, Supreme Court judge cannot plead below that. He can plead only in a high Supreme Court, right? That is the lower courts he should not. That is the standard pleading, okay, na, of Supreme Court and High Court. Next, removal or transfer of judge. Who will remove or who will transfer the judge? President. See, President can issue the removal order only after address by the Parliament which must be supported by a special majority of each house of the parliament. So, who will remove or who will transfer the Supreme Court judge? Transfer is not there. First of all, Supreme Court judge, removal is there. So, who will remove the Supreme Court judge? President. But President directly can't. President will remove only with the consultation with the parliament. In the parliament, especially in the lower house and upper house, the bill should pass with a special majority. Then only the judge can be removed. Otherwise, it is not possible to remove the judge. Okay, now, but in High Court, he can be removed by a president on the recommendation of the parliament. So here also, he can be removed by a president on the recommendation. So in both cases, you can take Supreme Court judge and High Court judge. The president can remove, but only with the recommendation of the parliament, with a special majority with the parliament. That is very, very important. You should remember. Right. Now, salaries and pension. See, salaries and pensions of Supreme Court judge, they will get from the Consolidated Fund of India. See, they will get from Consolidated Fund of India. The salaries and allowances of Chief Justice of India and Supreme Court judges are charged from the Consolidated Fund of India. Okay, na? Consolidated Fund of India. Now, here the salaries and allowances of High Court judges, including Chief Justice, okay, are charged from Consolidated Fund of State. Remember, salaries and allowances they will get from Consolidated Fund of State, but pension is drawn from the Consolidated Fund of India. Pension is drawn from the Consolidated Fund of India. So this is the basic information about the Supreme Court and High Court. Right. Now see here, appointment of judges of High Court. So Chief Justice of High Court. So Chief Justice of High Court is appointed by the President. Okay. President after consultation with the Chief Justice of India and Governor of the state. Okay. See, Chief Justice of India and Governor of the state concerns are consulted by the President. So definitely, President should consult the Chief Justice of India and Governor. And other regular judges of High Court. So these other regular judges of High Court is also appointed by the President after consultation with the Chief Justice of India and Governor of the concerned state and Chief Justice of the concerned state if it is necessary. So to appoint other judges, should consult Chief Justice of India, Governor of the state and Chief Justice of the concerned state. Right. Acting Chief Justice. So in case the Chief Justice of High Court is not performing his duties, then any one judge of the same High Court can appoint as a Chief Justice of that particular High Court for a temporary period. See, that is acting Chief Justice. The President can appoint a judge of High Court as an acting Chief Justice of High Court when the office of Chief Justice of the High Court is vacant. So if there is any vacancy of the Chief Justice post, then any one of the judge should act as an acting Chief Justice, or Chief Justice of High Court is temporarily absent. If he is not present, Chief Justice is unable to perform the duties, then acting Chief Justice will act as a Chief Justice of that particular High Court. Who will appoint? The President will appoint as an acting Chief Justice. Okay, na? Now, additional judges. See, sometimes if there are more cases are there, to resolve those cases, sometimes the President can appoint the additional judges. Okay, the President appoint the additional judges for what purpose? For a temporary period of not more than 2 years. For a temporary period of not more than 2 years, when there is a temporary increases in the business of High Court, okay, or there are arrears of the work in the High Court. Okay, na? Now, retired judges. Sometimes the High Court use the retired judges of the High Courts of a same state or a different state. See, the Chief Justice of High Court can request. Remember, Chief Justice of High Court can request a retired judge of a High Court or any other High Court to sit and act as a judge of High Court. Okay. And it can be done only with the previous consent of the President. So, for this purpose also, I should give the permission from the president, and also of the position person to be appointed. Okay, na? So to appoint a retired judge as a judge of a high court, so the chief justice of that high court can appoint, but he should consult the president, that is a retired judge. Now you can see the complete details here. See, you can see the tenure of a high court judge. See, constitution is not fixed. Constitution has not fixed any tenure, but he holds office until attains age of 62 years. Okay, he can hold the office until attains age of 62 years. Resignation, how he will get the resignations here? He can resign from his office by writing to the president. Remember, not to the chief justice of that high court, writing to the president. Writing to the president. And transfer, the president can transfer a judge from one high court to another after consultation with the chief justice of India, that is a collegium system. So the president can transfer a chief justice of one high court to another chief justice of that high court. So after consultation with the chief justice of India, the chief justice of two state high courts, like one from which the judge is being transferred, another is receiving him, also needed to be consulted. So chief justice of those high courts, they are also to be consulted to the president. And removal, the removal of the high court judge can be done in a manner of same as the Supreme Court judges. So if you want to remove a high court judge, definitely the president, but after consulting with the parliament with a special majority in the lower house and upper house. Based upon that, along with the Judges Inquiry Act 1968, the impeachment of judges can also be done on two grounds. One is a proved misbehavior or incapacity. Proved misbehavior or incapacity, we can impeach the judges of a high court and Supreme Court. Right. This is the basic information about the vacancy, tenure, resignation, transfer, removal. Okay, na? So vacancy is created due to age attaining 62 years or by resigning, by transferring, removal. Right. Now, after appointing the judge, there is oath or affirmation. Who will done this one? See, this is actually from the Constitution of India, 3rd schedule actually. Okay. Now, before the governor of the state, see, this oath or affirmation done before the governor of a state or some person appointed by him. Remember, this affirmation or oath is done before the governor of the state or some person appointed by him to uphold the constitution and the laws and the sovereignty, integrity of India. Okay, na? Salaries, I already said to you, salaries you will get from the consolidated fund of state. Salaries and allowances you will get from the consolidated fund of state, but pension they will get from the consolidated fund of India. Pension they will get from the consolidated fund of India. Next, the powers and functions of High Court. Now see here, as we discussed in the Supreme Court, the same powers and functions are there within the boundary, like original jurisdiction, writ jurisdiction, appellate jurisdiction, right, power of superintendent, court of records, and power of judicial review. All these things are also there for the Supreme Court, right? So same powers are there, same powers and functions are there. Now let us consider the first one, original jurisdiction, right? See, under this original jurisdiction, it is a power of a high court to hear disputes. It is a power of high court to hear disputes in the first instance, not by way of appeal and extended. So in the first case itself, so you can directly approach to the high court. This is a original jurisdiction actually, not by way of appeal. Okay, see here, enforcement of fundamental rights. Enforcement of fundamental rights, it comes under original jurisdiction. If there is any violation of fundamental right, you can directly approach to the High Court. Cases ordered to be transferred from a subordinate court involving interpretation of Constitution. So remember, this is important. If there is any case that is related to the interpretation of a constitution, then definitely that is comes under the High Court. Then, and matters related to will, marriage, divorce, company laws and contempt of court, all these discussed in the High Court. Disputes related to the election members of parliament. So remember, disputes related to the election members of parliament and state legislature are also discussed in the High Court. Regarding revenue matters, or act order are done in revenue collection. So related to revenue collection like tax collection, you can also discuss directly in the High Court. So the High Court has some original jurisdiction like a Supreme Court. Now writ jurisdiction. So the High Court can issue the writs. Under the Article 226 of the Constitution of India, empowers High Court issue some writs including habeas corpus, mandamus, certiorari, prohibition and quo warranto for enforcing fundamental rights and ordinary legal rights. Okay, now see, the writ jurisdiction of High Court is wider than Supreme Court. So everyone easily accessible for High Court. So that's why writ jurisdiction of High Court is wider than Supreme Court. Actually, in Chandra Kumar case versus Supreme Court, writ jurisdiction is a part of basic structure. So remember, writ jurisdiction is a part of basic structure. We can't disturb the writ jurisdiction. Okay. And appellate jurisdiction. See, the High Court hears appeals against the judgment of subordinate courts. So suppose if there is a case at a subordinate court, there is a judgment given by the subordinate court, you can approach to the High Court, right? It has appellate jurisdiction in both civil and criminal matters. It has appellate jurisdiction in both civil and criminal matters. Like any death sentence awarded by lower court should be confirmed by the High Court. See, suppose if there is any death sentence given by the High Court, definitely should be confirmed by the High Court, then only it is valid. Right? Now, the powers of a High Court is, one is power of superintendence. See, the High Court has a power of superintendence over all courts and tribunals functioning in its territorial jurisdiction. Okay, in a particular boundary of that particular state, overall territorial jurisdiction it has. Okay, judicial system it can apply in that particular boundary, including tribunals, but except military courts or tribunals. Military courts or tribunals are excluding from this power. Remember, it covers not only administrative superintendence but also judicial superintendence. Okay, so this High Court has administrative superintendence and judicial superintendence. High Court is consulted by governor in the matters of appointment, posting and promotion of district judges. District judges and appointment of a person to the judicial service. Okay, the governor can consult the Chief Justice of High Court for the appointment of district judges and other judges within the territory. Okay, so this is power of superintendence. Next, the court of record. So High Court also can store its cases, you can say, for future purpose, testimonial purpose. See, High Court has two powers regarding this court of record: the judgment, proceedings and acts. The judgments, proceedings and acts of the High Court are recorded for perpetual memory and testimony. They are recognized as a legal precedents and legal references. It has a power to punish for court of contempt of court, either with a simple imprisonment or with a fine. Okay, so same like a court of record, whatever the powers the Supreme Court is having, same powers it has. Okay, na? And the judicial review, power of judicial review, if there is a law or a bill passed in the state level that is against the basic structure of the Constitution, then the High Court has a power to say that it is null or void. Okay, now the High Court has a power to examine constitutionality of legal and executive orders of both central and state level. Remember, both central and state government. Okay, it is not only related to that concerned state. The High Court of any state can examine the constitutionality of a legal, legislative and executive matters. And Article 13 and 226 provides High Court has this power. The phrase judicial review is not mentioned, right? So High Court has a constitutional validity. It can verify related to the like infringement of fundamental rights. If there is any violation in the fundamental rights, the High Court can verify, can examine that, and it is outside the contempts of authority which has framed it. Okay, it is repugnant to the constitutional provision. So remember, these are the different powers related to the High Court. So same powers like the Supreme Court is having, the High Court is also having. So for your exam point of view, they will ask you explain the powers of a High Court. So remember, for your exam, like original jurisdiction, writ jurisdiction, appellate jurisdiction, okay, power of superintendence, court of records and power of judicial review.